guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. I don't know if you guys remember, but it's clear as day to me. In 2020, 25-year-old Ahmaud Arbery was shot dead. He was chased through a neighborhood in Georgia and shot dead by 3 white men. These 3 men, Travis McMichael, William Roddy Bryan, and Gregory McMichael, are the ones who chased Ahmaud because they thought he was burglarizing a home under construction, and they thought they could take it into their own hands to stop and gosh knows what. But they shot him dead. And Roddy is the one that shot this video from his cell phone as he chased the father and son. And I'm going to play that again as it states on the screen. Warning, it is a graphic video. There is no reason this should have happened. And obviously, a jury convicted these men. And now, they're trying to get the hate crime portion of their sentencing thrown out. It's ludicrous. It really, really is. So today, this morning, was the appeals hearing, the United States appeals hearing, to overturn the hate crime convictions against these 3 men. Again, Travis McMichael, Gregory McMichael, and William Roddy Bryan. Now, William, in the middle there, Roddy, he's the one that shot the video. And that is father and son, left and right. They're the ones that decided to take matters into their own hands and chase an unarmed man, an unarmed black man, and kill him. Kill him dead in the middle of a neighborhood street. And yes, this is a hate crime, and they have been charged as such. Again, the appeals court heard them today in Atlanta. And I'm really hoping that these 3 judges decide to toss their appeal. But we don't know yet. So I'm just going to sift through the article here on News Nation. Attorneys for the 3 white men who chased and killed Ahmaud Arbery in a Georgia subdivision asked a federal appeals court on Wednesday to throw out their hate crime convictions. They argued that prosecutors relied on their history of racist comments without proving they targeted Arbery because he was black. At the end of the day, this issue isn't about the racism of these defendants. A.J. Balbo, representing Greg McMichael, told a 3-judge panel of the 11th Circuit Court of Appeals in Atlanta. It's about whether or not the government met its burden. Well, I have to tell you, Balbo, they are hated. These 3 men are hateful. They are racists. I have no question in my mind that they are racists. I will play portions of the audio momentarily here. I really liked what some of the judges had to say in response to these attorneys. And it's only audio, but I will play a few key points there. Their arguments also strayed beyond the core issue of whether a racist intent to harm motivated the February 23, 2020 pursuit that ended with Arbery shot dead in the street. Defense attorneys raised legal technicalities, including their contention that prosecutors failed to prove Arbery was killed on a public road. This is ridiculous. This entire part of their argument is ridiculous. He's killed in a subdivision in a neighborhood. Federal prosecutors, they countered that the trial jury in 2022 heard sufficient evidence to find the trio guilty of hate crimes as well as attempted kidnapping. Racist views evidenced by the men's prior text messages and social media posts, they said, informed their mistaken assumption that Arbery was a fleeing criminal. The hate-fueled violence the defendants inflicted on Ahmaud is precisely the type of conduct that Congress targeted when it passed the Civil Rights Act, said Brant Levine, an attorney for the Justice Department's Civil Rights Division. Now, as we saw in the video, father and son, Greg and Travis McMichael, armed themselves with guns and used a pickup truck to chase Arbery after spotting the 25-year-old running in their neighborhood outside the port city of Brunswick. A neighbor, William Roddy Bryan, joined the pursuit in his own truck and recorded the cell phone video of Travis McMichael shooting Arbery at close range with a shotgun. These men, they chased him down. They chased down a man who was doing nothing wrong. Yeah, he potentially was trespassing on a construction site, but I'm sorry. They had no rights, no right to do any of what they did. Beyond calling 911 or calling law enforcement, and by going in their house, grabbing their weapons, their shotguns, getting in their truck, and chasing him. I mean, my mind is still blown to this day at what they did. It's appalling. This whole situation was disturbing from the get-go. There is police body cam out there of Ahmaud. He looked like he was breathing. Moving and breathing. When law enforcement arrived on the scene, nobody did a damn thing. Nobody did a damn thing to check on him. That's not to say the 3 gunshots wouldn't have already, taken his life. But it was as if nobody gave a crap about this man. And they didn't. It's obvious to me it was a hate crime. And obvious to the jury it was a hate crime. And I really do hope that this is tossed out and these 3 men just go back to their jail cells and just realize they were wrong. And apparently they're just never going to learn that we all bleed the same. We all bleed the same. I don't care if you're white, you're black, whatever. We all bleed red. And sadly, that's what Ahmaud bled out on that road that day.
May it please the court, my name is AJ Balbo and I represent the appellant Greg McMichael. I'm going to focus on issue 2 of our brief, and that is that the government failed to present sufficient evidence at trial with which a reasonable jury could have concluded that Greg McMichael acted against Mr. Arbery because of Mr. Arbery's use of a public facility or benefit. As the court is aware, in order for the government to sustain a conviction under 45B, they need to show 2 things. First, that a defendant acted because of another's race, and 2, that a defendant acted because of another's use of a public benefit. We maintain that the government failed on both prongs, but it is the second prong that I think that weakness is more glaring. When we talk about because in a statute like this, we are talking about but-for causation. And we look to the Supreme Court cases of Burrage versus the United States and this court's holding in U.S. versus Feldman for an explanation of but-for. We agree with the government that the causation does not have to be but it has to be determinative. It's the proverbial straw that broke the camel's back.
So are you saying that a defendant could if a person is a defendant going to make a race-based attack on someone in a variety of situations, then you can't prove that the fact that they also made the race-based attack because the person was on the street?
Your Honor, there's different ways that 245 5 tries to govern conduct. And we agree with the government that the purpose behind the statute is to punish or deter those who would forcibly try to suppress another from exercising a public benefit. So it's more than just simply jurisdictional. It's an essential element. I think the facts here overwhelmingly show that if Greg McMichael saw Ahmaud Arbery inside the house that was under construction and not on a street, he would have gone to him. He would have initiated.
Right. So he would have made, if you believe the evidence that the jury accepted, he would have made, which seems pretty overwhelming to me, he would have made an attack on Mr. Arbery because he was Black, because he was in an abandoned house, or because he was Black, because he was on a street, or because he was Black in any number of other situations. I don't think that means that he didn't make one of those attacks because he was on the street. The fact that you would make a broad variety of attacks doesn't mean that each reason can't count for something.
Yes, Your Honor, but the statute does not punish somebody simply for being racist or making a racist attack. It is to allow people to exercise federally protected rights, to give teeth to the Civil Rights Act. That's the purpose of the statute. So it is a necessary element that this take place, in this case, on a public street. And
So the jury could have concluded that the use of the streets was happenstance, but the jury did not.
Your Honor, I believe that it has to be more than just simply happenstance. The statute could have been written in a way to show that
your theory is happenstance. He would have, if he'd been running through the neighbor's yards, this was just happenstance. It was on a public street. That was your theory. The jury could have accepted it. The jury didn't. And you can't overturn that verdict if any reasonable construction would have allowed the jury to find your client guilty beyond a reasonable doubt.
That is correct. And this court does have to view it in a light most favorable to the jury's verdict. However, this court still has to make sure that the government has met its burden, that there was sufficient evidence put forward that a reasonable jury could have come to that conclusion. In this case, the overwhelming evidence is that Greg McMichael saw the person he saw on that video footage, judged that person by his height, his weight, his tattoos, his manner of dress. If this person had been a 60-year-old Black man, Greg McMichael would not have engaged him. The race was a non-contributing role in this matter.
But also evidence was put forth that when there was a suspected criminal who happened to be white, there was a use of the non-emergency line. There wasn't like, let's get in our trucks and chase that person down the street.
Your Honor, I see my time has expired,
Please.
But if I may answer.
Yes.
In that particular case, that 911 call that was made was engaged that white person under a bridge. So there was an engagement. It wasn't simply that he saw the person from afar and made a phone call. He engaged the person. And yes, does this display a hyper vigilantism? Yes. Is that praiseworthy? Is that something that to be encouraged? No. But the fact is, at the end of the day, this issue isn't about the racism of these defendants. It's about whether or not the government met its burden.
Thank you. You've reserved a minute for rebuttal. Mr. Theodosin, you also have 4 minutes with 1 minute for rebuttal.
Thank you very much. Good morning. My name is Pete Theodosin. I represent William Roddy Bryan. I want to focus on part 3 of my brief, which deals with the attempted kidnapping, 18 U.S.C. 1201, specifically the benefits clause. Of course, the government had to prove that the defendants attempted to confine Mr. Arbery against his will and hold him for a benefit. Now, the benefits clause is self-explanatory. The benefit doesn't have to be money. It's not just the traditional in the movies kidnapping. You can hold someone for a reward or ransom or any personal benefit, but you have to be acting out of a want of a personal benefit. Now, the cases that are cited are far different than this case. The cases in the government's brief, the Gooch case, which basically sort of defined what that meant, the defendant seized officers to avoid being arrested. They seized the confined officers, released them after they crossed state line. The benefit they were receiving was their personal freedom. Again, not money, certainly something of value to them. The 11th Circuit cases that are cited by the government, Lewis and Myers, the government suggests that those two cases highlight the, quote, sweeping coverage of the benefits clause. Again, far different than here. In the Lewis case,
Lewis was about, the defendant had admitted it was for companionship that he had kidnapped the person. I mean, that seems pretty broad of a benefit.
Yes, ma'am, but it's important to note the Lewis case was sentencing, and he was asked directly by the Senate saying, Judge, were you receiving a benefit? He said, yes. Asked specifically, what was that benefit? He said, well, I guess companionship. He had raped the victim during the kidnapping. The identical situation almost in the Myers case, the other 11th Circuit case. Again, the victim was raped during the confinement. And so in both those cases, even though they're presented for the proposition that they, out there like companionship or affection, those were very specific benefits that the kidnappers obtained, sexual relations with their victims. Again, far different than here. The kind of the one case that cited that had some sort of resemblance to this was the United States versus Parker, which dealt with the investigator who was trying to solve a case for his personal reputation. Again, that was a case.
How is that different? How is this not, whether it's vigilantism or, you want to be the neighborhood hero? How is that different?
It's different because that was a challenge to the defendants had filed a demur to the indictment, which was denied by the trial court. So they were challenging that rule, and the indictment had specifically indicated that that was going to be the benefit sought. And of course, the government would have had the right to prove that if there's any specific evidence of that. That was not a situation as we had here where it was just a speculative benefit.
But the jury was allowed to consider whether there was a benefit. And you've talked about different modes of proof for a few of these cases, but you've not talked about, I think, a more narrow conceptual framing for potential benefits, right? The benefit here, I think the government alleged, was vigilantism. The jury apparently decided that, among other things, was the case. So why can we disturb that finding by the jury?
I would argue that expansive usage of the benefits clause would render it useless. Okay, there's a difference between acting for your own personal benefit and acting. The government and the rest of the case has said, well, the reason these men acted as they did, they thought the young man was a criminal, and part of that was race-based. They were trying to go after someone who they thought had committed a crime. That's doing something for the community, not yourself. Right? They weren't going to get anything out of it unless you just use rank speculation.
Except they're a part of the community. I guess I'm not sure why a benefit that extends to the community doesn't also pick up them when they're members of the community.
Again, my time's run out. Could I answer, Your Honor? I think that would render this clause completely useless. Because when you think about the biggest sacrifice a person can make, you could always just speculate, well, they wanted to feel good about themselves. The young men that stormed the beach in Normandy going to their death, the government under this theory would say, well, they wanted to do it for their country. Everything's a benefit. So we're once you blend in a reason for doing something and a benefit, then really this clause is unnecessary. So what I would ask, and I'm going to sit down, what I would ask for the government to give us an example of a confinement that would not qualify under this statute, that you couldn't argue was a benefit. And I'm not sure there is one if you're going to give it the expansive interpretation that they suggest.
Thank you.
This attorney has the gall to try to argue that what they did as any kind of comparison to war and Normandy. I mean, how freaking ridiculous. It's not a benefit to the community, any of what they did. They were hateful, period. They were hateful. They did it for their own benefit because they did not like this black man on their street seemingly bothering a construction site, and and from what their texts and everything else, they were just hateful people. So no, as far as I'm concerned, that argument is just a bunch of crap. And I'm pretty sure the judges are going to see right through that as well.
My name is Brant Levine, and I represent the United States. I'd like to begin by focusing on what this case is really about. That Ahmaud Arbery would be alive today had not been a black man running on the streets of Satilla Shores. The hate-fueled violence that defendants inflicted on Ahmaud is precisely the type of conduct that Congress Civil Rights Act of 1968 and enacted Section 245. Nobody should have to fear that if they go for a run on a public street, they might end up running for their lives, being chased because of the color of their skin. That's why the defendants were charged with federal hate crimes. Now, in attacking the guilty verdicts here on the hate crimes charges, they fail for two primary reasons. First, they fail under the standard of review. As the district court detailed in denying the defendant's motion to acquit, this is not a close case. There's sufficient evidence to support each and every guilty verdict. And second, the defendant's challenges fail under but-for causation. Now, there doesn't appear to be any dispute that Ahmaud's race and Ahmaud's use of the streets need not be the defendant's sole motive or even a primary motive. But what I'd like to push back on is the premise of some of these arguments that this all started when Greg or Roddy Bryan first saw Ahmaud. That's not when this case first started. That's not a federal crime if they want to go investigate somebody who looks suspicious in the neighborhood. And in fact, had the McMichaels driven up to Ahmaud and said, "Excuse me, can we talk to you about what you were doing in that house?" we wouldn't be here today. We're here today because when they went up to Ahmaud, they pulled out their guns, they yelled at him to get on the ground, they threatened to blow his head off, and they chased him. And Roddy Bryan blocked his exit from the neighborhood so he couldn't leave until, in Greg McMichael's words, they trapped him like a rat. That is the context in which to evaluate the but-for race and but-for streets. Why did they take those extreme measures? Why did they terrorize Ahmaud for nearly 5 minutes? And on the evidence before the jury, that there's more than sufficient evidence to sustain the convictions on that point based on the defendant's own conduct that day.
So again, I think that it's clear this was a hate crime. I don't know what else they're all their arguments about it wasn't a kidnapping, it on the street and neighborhood, all this crap that these lawyers are throwing out, and how, especially all that crap about how they're helping like the war. I mean, it's what a bunch of crap. All I could say is they are throwing anything they can and hoping it will stick to the wall. And I hope and pray that these three judges come back and say denied. They're all guilty. They were found guilty by a jury, murder, and also of hate crime. They're racist, period. And to me, there's just no question in my mind. And Ahmaud deserves to have this justice stand. And this is the kind of people that we do not need in our country, in our world. These are hateful men. And it's got to stop. It's got to stop. But let me know what you guys think. Again, I think the all of us that follow this case saw the writing on the wall. We saw what happened. I know I followed the case, and I know a lot of you guys did as well. And that cell phone video alone, as well as all the evidence from the law enforcement of not only chasing this man down with guns in your trucks, and when cops come, they didn't even do a damn thing. So as far as I'm concerned, there are just so many guilty people that day, and it just started with the McMichaels. All right, guys, I hope you have a great rest of the day, and most of all, stay safe.